Hi, it's Mike DelSignore. In today's video, I want to talk about what happens if you receive a notice for a clerk magistrate hearing on an OUI charge. So if you received a clerk magistrate hearing on an OUI, what likely happened is you were in a crash, you were taken to the hospital. So the reason you got a clerk hearing is because you weren't arrested. So this is a great opportunity to potentially get the case dismissed or dropped. I've done a lot of these cases, and what will happen is you'll get a clerk hearing, and it's an attempt to show that there's no probable cause. So because you weren't placed under arrest, Massachusetts law gives you this clerk hearing. Now, most people, if you're charged with OUI, you go back to the police station, you don't get a clerk hearing, you're arraigned the next day. So the case starts much quicker. The benefit with the clerk magistrate hearing is in the right court, and this doesn't happen all the time, a lot of clerks are going to issue the complaint. But what I tell people, and this is the only way you're possibly going to get a break on the OUI, possibly going to get the case diverted or the complaint not issued, do some alcohol treatment, do something proactive, get some letters. So when I go into the clerk hearing, I can present that to the clerk and argue that you're someone that should be treated differently, that you've done everything, that it's not necessary for the case to be arraigned. You got the message, whatever the allegations are, you dealt with the issues that brought them about in terms of alcohol, in other words, going to AA. If it was alcohol in addition to some other issue in your life, you did some counseling. And if you do this, you got a chance. Now, often the clerk's going to say, appreciate that, still issuing the complaint. But I've had many cases in courts all over Massachusetts where the person's case complaint never issued because they did something proactive. What else is going to happen when you have an accident, a crash, and you have a clerk magistrate hearing? You're probably going to have an immediate threat suspension. So your license is going to be suspended indefinitely. You'll have to file an appeal with the Board of Appeals. The common mistake I see other lawyers make is they'll wait till a case is resolved, then file with the Board of Appeals. If you do that, you're going to wait much longer. It's about a 6-month wait for the Board of Appeals. So file it now. If we need more time, we can always put it off. But file it now so you're in line and you can get your license back faster than you otherwise would. The Board of Appeals, they're going to want to see the same things I'm telling you. You need to persuade the clerk. They're going to want to see evidence of alcohol treatment, counseling, things like that, regardless of how the OUI comes out. So it won't be a waste for you to do these proactive steps I'm talking about. You're going to need it for the registry anyway. You might as well do it right away. Now, what happens if the complaint is issued? A lot of times there's very little evidence in these accident cases. You went to the hospital. There wasn't much time for the officer to make observations of you. There might be a hospital blood test. These tests are not forensic tests. They're not accurate, reliable tests. So we can do motions to get this type of test excluded from evidence. So what a hospital blood test is, it's a screening test. Hospital doesn't care exactly what your blood alcohol is. They just want to know if alcohol is involved. So they do what's called an enzymatic test. It's not a forensic test, it's one test. So in contrast, a breath tests have a lot of issues with reliability, but one thing a breath test does is it gives two samples. In most cases within science, when you're testing something, you do two tests, two samples. A hospital blood test, they take one sample and that's it. And it's basically, it's not measuring your blood directly, but indirectly. So that's an argument we can make to a judge to get the breath test excluded. Sometimes we may need to hire an expert to explain the difference between an enzymatic test and a forensic test, and the fact that there's these conversions that they'll use, because the hospital's testing serum, the serum portion of the blood has a higher alcohol content than the whole blood. The law requires the blood to be tested be whole blood, so there's a conversion. That formula is not scientifically reliable. It's just an average. It's generally about what it is, so we can have an expert educate the judge on that. So if you have a clerk hearing charged with OUI, feel free to call me. My name is Mike DelSignore. Help people all over Massachusetts with OUI cases, immediate threats. You can call me at 781-686-5924. My passion is to help people charged with OUI cases. I've been doing this for over 20 years. Let me help you, guide you through the process, help you make the best decision for yourself and how to handle an OUI case and how to approach a clerk magistrate hearing. So call, text anytime, 781-686-5924. I'm here to help you.